And good morning to everyone in the US and the UK, and good evening for everyone in Asia. My name is Alex Saleh. I'm the managing partner of GLA and Company. And welcome to our webinar, Merger Control Developments in the MENA region, Filing and Exceptions. Quick background, GLA is a leading Arab civil law regional firm with offices in Saudi, UAE, Qatar, Bahrain, and Egypt. Today, in conjunction with our JV partner, Habib Al Mullah, where we have over 120 lawyers across the region. And for purposes of today, we have a number of specialized practice groups, including an antitrust and competition practice. Today, we're going to explore key topics involving the definition of economic concentration, financial thresholds for filing, and potential exemptions. One unique thing about GLA and Company, as a local Arab civil law expertise firm, we have amazing relationships with all the regulatory bodies across the region. So without further ado, I'd like to introduce the team members. Representing Qatar is Dean Jaludi, our head of office there, Mohammed Al-Mendil, our head of Saudi office, Khalid Al-Makhazin from Kuwait, Khalid Al-Khashab for Egypt, and the head of our antitrust and competition practice, Asad Ahmed. Without further ado, I'll turn it over to the team.
Thank you, Alex. Welcome, everyone, and thank you for joining us. We have a lot to cover today, so without any further ado, let's jump right in. Any merger control assessment begins with the definition of the term economic concentration and whether a transaction would fall within the scope of this definition. Generally, we'll find many similarities in how the different MENA jurisdictions define this term. Let's begin with KSA and Hamid Al-Mandil. In KSA, what is the definition of economic concentration under the competition law there?
Good afternoon to all. Thank you, Asad. Well, under the Saudi competition law, which was issued in 2019 and regulated by the General Authority of Competition, economic concentration is defined as any activity that results in the total or partial transfer of ownership of assets, rights, stocks, shares, or obligations of an entity to another, or in the combination of two or more managements joint into one management. This is according to the law.
Wonderful. Thank you so much, Mohammed. Moving swiftly on to Kuwait and Khalid Al-Makhazim. Under the Kuwait competition law there, what are we looking at in terms of the definition of economic concentration?
Here in Kuwait, economic concentration is a situation involving a permanent change of control in the relevant market, arising by way of merger or takeover, as well as the establishment of a partnership between two persons or more, providing an economic activity independent of them on a permanent basis. There are specific situations which is deemed as economic concentration. First is the merger between two persons or more by way of absorption or combination, or the combining of parts of person that may lead to control or increase in control. Second is the acquisition of direct or indirect control by one person in all or parts of another person or persons, whether the acquisition of assets, ownership rights, purchase of shares, stock, liabilities, or by any other way. The third is the existence of partnership between two persons or more that leads to a permanent and independent economic or commercial activity, regardless of the legal form or activity exercised.
Very clear, very clear. Thank you, Khalid. Makhazim, let's move on to Egypt with Khalid Khashab. Khalid Khashab, what are we looking at in terms of the definition of economic concentration under the Egyptian competition law there?
Well, in Egypt, and similar to the other jurisdictions in the region, the economic concentration is defined mainly by the instances of change of control or exercising material influence. Now, the Egyptian competition law, per the latest amendments and the executive regulations that introduced the ex ante merger control regime, it defines the control as the ability of one or more controlling person to exercise decisive influence directly or indirectly over one person or another. This could be through acquiring majority of voting rights, could be the ability of the controlling person to block economic decisions, or a combination of such actions. Now, similar to other jurisdictions, of course, this could be in the forms that are economically known, such as the acquisitions, mergers, and even in joint ventures in specific cases. But one of the distinctive aspects you can look at this in terms of control, that control could be defined by the ownership of 50% or more of the total rights. It could be ownership of rights to exploit majority of the assets of the controlled person. It could be also the right to act to lead more than half of the board of members of the board of directors, or the General Assembly into certain decisions. Now, material influence is a case that focuses more on lesser shareholding rights. Now, in accordance to the ECL and the executive regulations, uh, material influence is the ability to influence the policy or the strategic decisions or the commercial objectives of one person. This could be in cases where an influential person has 25% of the voting rights or the shareholding percentages addressed, or even less than 25%, but if such capabilities exist. But by all means and significantly, if you own less than 10% as a controlling person or an influential person, you're usually not within the scope of an economic concentration, but provided that you're at least not within the top three shareholders in terms of shareholding percentage if you're below 10%.
Perfect. Thank you so much, Khaled. All clear. Moving on to Qatar and Dean, what are we looking at there in terms of the definition of economic concentration under the competition law?
So under the competition law of Qatar, which was issued in 2006, and the regulations, which were implemented in 2008, yes, they are both quite old at this point. The term economic concentration is not actually explicitly used or defined, but it can be inferred just from context within the law. And in Qatar, the events, which are essentially economic concentration events, are similar to the ones that we see across the region. So they are those events would be, transferring or gaining ownership of assets, or usufruct rights, or buying shares of a company, or establishing joint ventures, or participating in mergers, or even combining the management of two or more legal persons. All of these in a way which would lead to control or domination of the relevant market. So these are essentially the events that are considered economic concentration events under the competition law in Qatar.
Perfect. Thank you so much, Dean. So, you see the similarities and a bit of the distinctions between the different jurisdictions when it comes to the definition of economic concentration. Assuming you fall within that definition, then the next question that you need to ask yourself is, hey, do I meet any of these financial thresholds? And is there a objective local nexus in that jurisdiction that also applies to me? So beginning with KSA and Hamad al-Mandil, can you let us know how KSA addresses this question?
Sure. Well, under the law as well and the regulations issued by GAC, the General Competition Authority, there is a test exercise that must be met, and it has three elements. The last of which has a local nexus. The first is the economic concentration must be notified if the total annual sales value of all entities intending to participate in the economic concentration exceeds 200 million Saudi riyals. There's the second element is the target sales threshold, where the annual sales of the target entity inside and outside Saudi Arabia in economic concentration must exceed 40 million Saudi riyals. However, The third element, which was introduced recently in 2023, where the board of directors have added this local element and local nexus to it, which is a local sales threshold, where the total, well, combined total sales realized locally in the territory of Saudi Arabia by the parties to the economic concentration must exceed 40 million Saudi riyals as well.
Perfect. Thank you so much for that. And obviously, that entails a local nexus that must exist in order for a merger control filing to be triggered, along with these
Sure, and I
financial
repeat that
thresholds.
all three elements must be achieved. Otherwise, it wouldn't be necessary to file.
Very important, very important. Thank you so much, Mohammed. Moving on to Kuwait and Khalid al-Makhazim. What are we looking at there in terms of applicable financial thresholds? And does Kuwait have a local nexus?
Yeah. As for the financial thresholds, an economic concentration application filing is required where any of the parties to the transaction meets one of the three thresholds according to the audited financial statements of the parties from the last financial year. The first is if any of the parties to the agreement achieves sales in Kuwait that are greater than 500,000 Kuwaiti dinars, approximately 1.6 million US dollars. Second is if the aggregated sales of the parties to the agreement is greater than 750,000 Kuwaiti dinars, approximately 2.4 million US dollars. Third is the value of the registered assets in Kuwait of the parties involved in the agreement exceeds 2.5 million Kuwaiti dinars, approximately 8.2 million US dollars. For the local nexus, Kuwait does not have an express objective local nexus requirement. Kuwait utilizes the current financial thresholds and assumes if one of the parties involved in the transaction meets the financial threshold, then the transaction could have an impact on the local market here in Kuwait.
Perfect. Thank you so much, Khalid. I think it's important to note, specifically in Kuwait, that if one of the parties involved in economic concentration meets one of these financial thresholds, immediately there is a mandatory merger control filing required. So thank you so much for that, Khalid. Let's move on to Egypt and Khalid al-Khashab. What are we looking at in Egypt in terms of applicable financial thresholds? And is there an objective local nexus requirement?
Well, as at the law upon the introduction of the merger control regime, it stated that the financial thresholds could be calculated or could be attained on two different calculation methods, if you wish to call them. Now, as stated before, if an economic concentration meets the criteria, it has to be filed, but it also must meet the financial thresholds that are one, considering a domestic look. If the parties to the economic concentration's total annual turnover or the registered assets in Egypt exceeds an amount of 900 million Egyptian pounds, which is roughly $17 million. And the turnover of at least two of these parties in the concentration exceeds 200 million Egyptian pounds, which is about $3.9 million, then the financial thresholds would have been met. Now, there is another threshold that could also be calculated and could be attained if most of the operations is not within Egypt. That would be what we call a global turnover mechanic. That is, if the global combined turnover of the parties to the concentration exceeds 7.5 billion Egyptian pounds, which is roughly $149 million, and at least one party realizes revenues in Egypt that exceeds 200 million Egyptian pounds. I have to note that in such a case, this party should be the target company in an acquisition. And of course, there is the local nexus, as explained above that. In the domestic aspect, we're looking at two persons at least realizing the 200 million Egyptian pounds, while in the global threshold, at least one person should be realizing the 200 million pounds the target company has stated. Now, interestingly, the ECA, though, prescribes under Article 19 bis, of the ECL, and as elaborated on Article 61 of the Executive Regulations, that the Egyptian Competition Authority, as the entity that is overseeing the application of the ECL, it does have the ability to review economic concentrations that do not meet the notification thresholds within 1 year of their implementation. But in cases where such concentrations may lessen or restrict or harm the competition in the Egyptian markets.
Thank you so much, Khaled. No, I think that last point is definitely important for people to know the discretion of the ECA when it comes to their ability to look into transactions and the statutory period they have to do that. So very important. Thank you so much. Moving on to Qatar and Dean. Dean, how are you looking in terms of the applicable financial thresholds in Qatar? And is there an objective local nexus requirement there?
So Qatar is different from the rest of the region in one way in particular, that there are absolutely no quantitative financial thresholds in the law. So, and this is something that we've essentially confirmed as well in practice. We have an excellent relationship with the competition authority in Qatar, and their view is consistent with what is written in the law, which is that there's no specific quantifiable financial threshold. It is a qualitative test instead, and that qualitative threshold is, again, domination or control of the relevant market. So if there is a contemplated transaction, merger, joint venture, combination of management, and even if that is foreign to foreign, the relevant test is whether that transaction would lead to domination of the relevant market in Qatar. And that sort of ties into the second question, which is the local nexus. Again, there is no local nexus requirement whatsoever. So foreign to foreign transactions can indeed trigger a filing obligation in Qatar. If you have, let's say, a potential merger between two foreign companies with no legal presence in Qatar, but whom each ship or export into Qatar, very important, equipment, let's say cranes or construction equipment or things of that nature, defense. If those entities have a significant share of the Qatari market, then that would most likely lead to a notification requirement.
Perfect. Thank you so much, Dean. And I think it's important to note the position of the regulator there in terms of how they read the law and what they're going to apply in their practices. So thank you for that information. Moving swiftly on to the next question. Now, assuming that you fall within the definition of economic concentration, and you happen to meet these financial thresholds. Now, the next question that we usually get is, hey, do I fall within an exemption or an exception under the law? Is there a category that I can try to get around filing? So starting with KSA and Hamad al-Mandil, how does the KSA competition law deal with this question? Are there any exemptions under the competition law there?
Yes, the law actually provide the exemption factor, and you can actually apply for a competition restriction exemption, and it may be granted if it leads to certain elements, which is an improved market performance or enhances the quality, technological development, or efficiency of undertakings. However, all come to the ultimate aim for the consumer benefit outweighs the negative impact on competition. The practical application process takes, as in you have to submit and follow all the formats and forms specified by the executive regulations of the competition law, provide adequate justification of that exemption and sufficient evidence of the positive outweighing the negatives of what is expected, and also provide all the supporting documents and required information that may be asked by the authority. I have to mention, in practice, the documents submitted in Saudi have become less complicated in terms of the Saudis not requiring anymore the legalization. And since joining in 2022 with the Apostle Convention, they accept these documentation to be legalized in their own countries without requiring the embassies legalization, etc. However, the General Authority Competition Board will be basing their decision on a technical committee and the recommendation, if it approves the application, that it falls under the three elements mentioned, which is improved market performance, in terms of quality, diversification, technological development, and innovative efficiency. Again, the benefiting consumers outweighing the competition restrictions, and it does not exclude competition or competitors from the market. However, all three must be met for the board of the GAC that can be able to provide such exemption.
Thank you so much, Mohammed. So, KSA clearly allows an avenue for parties to apply and try to gain this exemption. And as described by Mohammed, they have objective criteria that they try to assess in hopes it's met. Moving swiftly on to Kuwait, Khalid Makhazim, what are we looking at under the competition law in Kuwait in terms of possible exemptions or exceptions that parties can fit into?
The Kuwait competition law exempts certain activities from being deemed as economic concentrations. Banks, insurance companies, and financial institutions whose activities include trading in securities are exempt, provided they do not exercise substantive voting rights conferred by such securities. The security must generally be disposed of within 1 year from the date of acquisition. Additionally, acquisitions resulting from insolvencies, defaults, debt restructuring, compositions with creditors, or similar transactions are exempt. Also, restructuring within the same group of companies is exempt as well.
Okay. Very clear in Kuwait in terms of the exemption categories offered by the competition law there. Moving on to Egypt and Khalid Khashab, what are we looking at in terms of exemptions under the competition law in Egypt?
Well, Asad, such as or a little bit different from case in Kuwait, the ECL does not recognize specific exemptions such as that for financial institutions in Kuwait, but it does, however, state that the ECL in general does not apply to public utilities management directly by the state, which could exclude a lot of their operations. Now, however, the ECA, an application of the ECL, can implement or allow the clearance for some of the economic concentrations upon the approval of the Cabinet of Ministries, but in very specific sort of criteria. One of which would be if the non-implementation of the economic concentration that is filed would result in an exit of one of the parties out of the market in what we call a failing firm scenario. The other would be the implementation of the economic concentration would have economic efficiencies that would outweigh its anti-competitive effects. And finally, if for some reason that is assessed that the ECA would find that the economic concentration in question is related to the protection of the national security. In all three scenarios, these economic concentrations would be cleared even if they sort of do not meet the criterion, or if they still need further review.
Okay. Thank you so much, Khalid. All clear from Egypt. Moving on to Qatar with Dean. Under the Qatar competition law, what are we looking at in terms of possible exemptions?
Sure. There are three main categories of exemptions in Qatar under the competition law. So the first would be for economic concentrations, which would be in the benefit of consumers. And the second would be for transactions which would be positive for economic development. And the third is for transactions involving Qatar state-controlled entities. So obviously, for the first two, this is quite subjective. You cannot just have parties to a transaction unilaterally make the determination that this proposed merger or that proposed transaction is good for consumers or good for economic development. Of course, you would still probably want to file to be on the safe side and receive that waiver. And then even on the third one, for transactions involving state-controlled enterprises, that analysis can be a little bit tricky because the competition authority could very much get into the details about government ownership percentage or control of the board of the relevant entity, or even the details of how the state has control or sort of management control over the relevant entity. So sometimes this analysis can be quite fact intensive and done on a very case by case basis. But those are the three main categories of exemptions in Qatar.
Perfect. Okay, thank you so much, Dean. All clear. Moving on to our next important question. And now, assuming that, okay, I do fit within the definition of economic concentration, I'm meeting these financial thresholds, and unfortunately, I can't find an exemption to fit under. Then the next query with respect to transactions usually is, how long is this going to take me from submission until clearance of an economic concentration application? And we'll begin again with KSA and Mohammed Al-Mandil. What are we looking at in terms of timelines there?
Sure. Undertakings seeking to participate in an economic concentration must be filed, which we have to mention, with GAC at least 90 days before the completion of the transaction. The competition law provides that the undertakings participating in the economic concentration may not complete the transaction unless notified by the GAC of its approval in writing. However, we have to mention that after paying the fees, this is very important to mention. If the 90 days have elapsed since the review period of the GAC commenced, or if it has not provided an approval or rejection, the 90-day regulatory review period will begin on the date on which GAC notifies the applicant that the notification submission have been completed. However, from a practical point of view, in Saudi Arabia, we've seen it that it is taking normally between 45 to 60 days from the submission until clearance.
All clear. Thank you so much, Mohammed. Moving on to Kuwait and Khalid Al-Makhazim. What are we looking at in terms of timelines from submission until clearance of an economic concentration application with the CPA?
The law requires submission of an application to the Kuwait CPA by persons involved in the economic concentration within at least 60 days from the date of the contract or agreement regarding the transaction. Once the application is submitted, the CPA has 90 days review period to prepare a report to the CPA's board of directors. The 90 days period could be extended for an additional 90 days if necessary. It generally takes around 60 days to obtain a clearance from the CPA after submitting the filing. I would like to also note that implementation may not lawfully proceed before an approval is issued by the Kuwaiti CPA.
Thank you, Khalid. I think that's a very important point to make. And then just one other distinction between maybe KSA and Kuwait is the fact that, as Mohammed mentioned earlier, KSA is a party to the Apostille Convention, so it might be a little bit quicker to get the documents and submit that application. Moving swiftly on to Egypt and Khalid Al-Khashab, what are we looking at in terms of timelines there with respect to application submissions and clearance?
Well, as in Egypt, the ECL does not prescribe a specific timeline before implementation that an entity or parties in economic concentration should file before, but it is again tied to implementation. An economic concentration filing must be submitted before implementation. At whatever stage, the ECL prescribes a wide range of or a spectrum of actions by which when you conclude, you can file. This could be at the time of an MOU, it could be at the time of negotiating the economic concentration, at the time of a purchase offer, or even at the time of concluding the agreement, the definitive agreement. In terms of timeline for review, it starts simply with the completion period. The ECA has 5 business days to review once a filing is submitted, and can inform the parties within such 5 days if any further documents are needed, which would extend the timeline by more 5 business days to conclude the application itself and deem it complete for the review to proceed. Once the review starts, the ECA usually takes 30 business days to conclude the review of the application, and that could be extended by 15 working days as well if there's a commitments offer that should be submitted by the parties. Um, Similar to other jurisdictions, once the time lapses and there is no formal approval or clearance, then this would be considered an automatic approval. Now, these are in business days, but the average we've seen in practice is that it takes about, similar to KSA, all around 45 to 60 calendar days until it's concluded. Now, there is a second phase when the ECA deems it necessary that a second review takes place for an economic concentration. That would take about 60 working days with a possible 15-day extension. Again, this is in very specific cases that would require a second review or a phase 2 review. The economic concentration results, which is specifically the cases of refusal, can be appealed with the ECA within 30 days of their notification. After that, the same timelines remain unchanged in the cases of acquiring a target that is regulated by the Financial Regulatory Authority in Egypt. In such case, the FRA is the entity before which you file an economic concentration application, but with a consult from the ECA. But the timelines remain unchanged accordingly.
Okay, thank you so much, Khalid. I think it's important to note that, especially with respect to the Financial Regulatory Authority, having basically taking the lead on those entities, that's very different than other jurisdictions. Um, Now, let's move forward with Qatar and Dean in terms of timelines there, and from submission until clearance of the economic concentration application. How's it looking on your side?
Sure. So under the competition law, it's a familiar 90-day timeline. So parties have an obligation to notify between signing and closing, and they cannot proceed to closing without obtaining that clearance from the competition authority. Under the law, the competition authority must provide the response within 90 days, and failure to do so is deemed as approval of the proposed transaction. In our experience, however, we would say that the authority is actually much faster. The committee usually they provide us responses in far less than 90 days. However, in the event that they are going to completely approve with no comments, then it is normal to just have the 90 days completely lapse without any update, and then that would again be deemed approval on which the parties can just proceed.
Okay, thank you so much, Dean. All clear from Qatar. Let's move on to the next question, which is also a very important question, generally asked by clients. Is what is the economic concentration application filing fee in each of these jurisdictions? And it is different from one jurisdiction to the other. Let's begin with KSA and Mohammed Al Mandid. What are we looking at in terms of the GAC filing fee for an economic concentration application?
Well, it is called the notification fee. So the fee to be paid for examining the economic concentration, and the notification fee is 0.02% of the total annual sales value of undertakings intending to participate in the economic concentration. However, with a maximum price tag of 250,000 riyals. Again, we mentioned the parties must pay the notification fees before submitting any notification, and must submit proof of payment to GAC along with other notification documents and information required. The GAC requires that particular proof of payment before the notification will be considered complete.
Okay, perfect. Thank you so much, Mohammed from KSA. Now, with respect to Kuwait, Khalid Makhazim, what are we looking at in terms of applicable filing fees there with the CPA?
Here in Kuwait, there are filing fees, and applications must be accompanied by a receipt for payment of a fee equal to the lesser of 1/10, 0.1% of the paid-up capital of both parties to the economic concentration, or of the combined assets of both parties in Kuwait, whichever is less. The fee is capped at 100,000 Kuwaiti dinars, approximately 320 US dollars, 320,000 US dollars. Also, I would like to note that the CPA does not accept a filing fees to be equal to zero, as the application require has we, as we have to attach a receipt of payment to the application while we submit the application to the CPA.
Understood, understood. Thanks, Khalid. I think that's also an important point because a lot of these foreign transactions perhaps don't have any assets in KSA, so they try to go with a zero filing fee. However, pursuant to the CPA itself, they will not accept these applications, and they will be rejected or viewed as a way to try to get around the payment of the fee, and it will not be accepted by them. Moving on to Egypt and Khalid Al-Khashab, what are we looking at in terms of filing fees with respect to applications there?
Well, Asad, in Egypt, the ECL prescribes a multi-category tied filing fee. To put that into perspective, the filing fees for the economic concentration by all means do not exceed 100,000 Egyptian pounds. This hits around the $2,000 mark. With that being said, in the case of calculating the financial thresholds according to the domestic threshold that we addressed before, as high as the amounts get, as different as the category of the filing fee gets. So there is a prescription of an 80,000 Egyptian pounds or $1,900 filing fee if the combined annual turnover or the assets in Egypt of the economic concentration parties fall between 900 million Egyptian pounds and 1 billion. Now, that is raised to 90,000 Egyptian pounds if such amounts range between 1 and 1.5 billion Egyptian pounds. And finally, you hit the cap of the filing fees, which is 100,000 Egyptian pounds, if the amount or the annual turnover or the assets exceed 1.5 billion in their value. Now, directly in the case of going with the global turnovers or the global asset calculation, then as long as you exceed 7.5 billion Egyptian pounds in combined annual turnover and one of the parties is realizing the 200 million Egyptian pounds, you will stick with the highest category, which is 100,000 Egyptian pounds. Now, it has to be noted that if there are more than one category that apply to the economic concentration, it will be calculated on the higher category that is available.
Okay, thank you so much, Khalid. It's so interesting to see how these different regulators and jurisdictions decided to take different approaches with their filing fees, and in Egypt being a category-based is also very interesting to see. Let's move on to Qatar and Dean. What are we looking at in terms of filing fees from Qatar?
Well, actually, Asad, we have the most different approach yet in Qatar. Qatar is the only jurisdiction in the region that has no filing fees whatsoever, zero. So
Oh, wow.
There's no reason not to file. It's free.
Fantastic. So I'm sure all the parties and anybody of the attendees listening, they'll be happy to hear that, assuming that this is applicable to them. So thank you so much, Dean. Let's move on to the next question. This is also always a very important question that we get asked by the foreign parties is, hey, um, what in fact can potentially happen if we don't file, or if we forgot to file, we glossed over this jurisdiction? What are the gun jumping penalties for implementing before clearance, right? We can begin with Mohammed Al-Mandid in KSA. How does the GAC handle this?
Well, gun jumping penalties are mentioned clearly in the law, and particularly in Article 19, where it states that without prejudice to the provisions of Article 24 of the law, any person violating a certain aspect of violating the submissions shall be subject to a fine not exceeding 10% of the total value of the global annual sales subject to that violation. And it does not exceed 10 million reals. However, the GAC gives itself, or the law gives GAC the discretion where if it's not feasible to estimate the annual sales, the committee under GAC and at its discretion may impose a fine not exceeding 3 times the gains the violator accrues from the commission of the violation.
Perfect. Thank you so much, Mohammed. I think the one important word there is global annual sales, right? Everybody asks, is it local sales or is it based off of global? And as you confirmed, it is the global annual sales figure that they look at and base any financial sanction on. Okay, moving on to Kuwait and Khalid Makhazim. What are we looking at in terms of potential gun jumping penalties there?
The law in Kuwait provides a rate that does not exceed 10% of the total revenues of the concentration participant during the preceding financial year. In case of failure to submit the concentration application set out in Article 12 of the law. I would like to note also that the CPA monitors media networks for any transaction-related announcements and also coordinates with foreign competition authorities on such matters. They issue investigatory letters to involved parties, both within and outside Kuwait, which must be responded to.
Okay, thank you so much, Khalid. We've been involved with potential investigations from the CPA, and they have in fact gone outside the territories and sent out queries to parties that have turnover in their jurisdiction, and you must respond to these queries or be subject to potential financial sanctions. So thank you so much, Khalid, for that information. Let's move on to Egypt and Khalid Al-Khashab. What are we looking at in terms of potential gun jumping penalties under the ECL?
Now, Asad, per the ECL, the economic concentration that would not comply by being filed would be subject to a penalty that ranges between 1, but no more than 10% of either of the total annual turnover, the value of the assets, or the value of the transaction itself. But that, of course, if the amount can be identified from the audited financial statements of the latest available. Now, if such amount cannot be determined due to the lack thereof or non-cooperation, then the fine would be an amount that ranges between 30 to 500 million Egyptian pounds.
Wow.
I have to note as well that similar to other jurisdictions, the ECA is very active in terms of getting the merger control regime at its peak performance. And similar to the practices they have in other anti-competitive areas, they are very keen on monitoring the news of the world, if you wish to call it, and cooperating with other authorities inside and outside Egypt. So it is very important that these penalties be observed.
Okay, thank you so much, Khalid. Yes, it is imperative to note that these competition authorities, in fact, do have workshops, they do communicate, and they do have meetings annually, if not more than that. I think we want to move on to Qatar and Dean with respect to this question. What are we looking at in terms of Qatar and possible gun jumping penalties there?
So penalties under the law against both gun jumping and other violations of the competition law range between 100,000 rials to 5 million rials, which is roughly equivalent to about 1.3 million US dollars. And additionally, the competition law in Qatar has a somewhat unique feature here in that courts may also impose as a penalty the seizure of profits from any offending activity. So that could be, usually applied to, let's say, anti-competitive behaviors, but it could also be applied to gun jumping as well. Seizure of profits, in addition to possibly 1.3 million US dollars, that's a max penalty. That's a pretty hefty penalty, especially when you consider that it's free to file and that it's difficult to assess which situations require a notification in the first place. All of this taken together kind of pushes you in a very specific direction.
Very true, very true. Qatar is incentivizing everybody to file, so that's important to note here. All right, we are done with that segment. Thank you, gentlemen. That was very informative, and we really appreciate it. Moving on to our next segment, with respect to the UAE competition law, where the most recent regional development in the merger control landscape has taken place. So I wanted to discuss that a little bit and, flush out some of the provisions that have come out, and then try to discuss potential ways to deal with the gray area that we're in for the time being, and my recommendations to you guys in the event this is applicable to you or your clients. The UAE issued their new competition law under Federal Decree Law number 36 of 2023, and this came into effect on the 29th of December of that year in 2023. The new competition law repealed the old UAE competition law of 2012. Now, the new competition law provided the framework for the regime. However, it pointed to the executive regulations with respect to many substantial points, including a new turnover financial threshold, which was very interesting to see that the UAE was going this route, but so has many other, of its neighboring jurisdictions. So it wasn't abnormal to see. The executive regulations of the new competition law were anticipated to be issued in June of 2024. Unfortunately, this did not happen. Now, what did happen most recently was on the 20th of January, which was less than a month ago, the Cabinet Resolution number 3 of 2025 was issued. The resolution seemed to be part of the long-awaited competition law executive regulations, provided for a new turnover threshold, wherein if the parties to the economic concentration have a combined annual turnover in the UAE that exceeded AED 300 million, which is approximately $81.7 million USD, in the last year, a financial year, then a mandatory merger control filing is triggered. So this did not exist, before the 20th of January when this resolution was issued. But the resolution also still re-emphasized the market share financial threshold, which carried over from the old competition law, wherein an economic concentration is notifiable in the event the parties' combined market share in the UAE exceeded 40%. So you still had both of these thresholds that can each, on their own, meet and trigger a economic concentration filing. Now, it's important and it's imperative to note that the Cabinet Resolution will go into effect the 31st of March, 2025, right? That's when it's set to go into effect. And taking just a little step back here for reference, the new UAE competition law defines economic concentration broadly, which is any act resulting in a complete or partial transfer of ownership. In general, that's the definition. It must include a transfer of control, of course, from one party to another. This would encompass mergers, acquisitions, joint ventures, where one party gains control over the other. The new competition law does not provide for any exemptions other than government-owned entities or where the goods or services are addressed under another law, okay? With that being said, I would argue that a restructuring exemption is implied based on the definition of economic concentration and the requirement for a shift of control. Thus, in the event a transaction does not fall within the definition of economic concentration, I would argue that the mandatory merger control filing is in fact not triggered. Now, let's go back to the anticipated executive regulations, right? After the publication of Cabinet Decision 3 in January, there are still lingering questions regarding the treatment of joint ventures, especially non-full function joint ventures and minority shareholdings. We hope the executive regulations will address these questions. Now, through our discussions with the regulators as recently as this morning, we expect the executive regulations of the UAE competition law to be issued between the end of this week and early next week. So I understand everyone is anxious, especially those parties in the midst of closing that did not take into consideration a UAE merger control filing. My recommendations to all of you are as follows. I would obtain a merger control assessment as quickly as possible. I would consider the transactions which will not close before 31 March to be the first priority in terms of assessments and filings. In the event the transaction is a merger or acquisition, and the parties in fact meet the turnover threshold, the new turnover threshold, then I would engage counsel and begin preparing the application as well as collecting the required documents to be submitted to the Ministry of Economy. Now, a couple of things to know about the process itself that you should take into consideration now. The documents required attestation must therefore be physically sent to the UAE and finalize the attestation with the UAE Ministry of Foreign Affairs. This takes time. Please take that into consideration. The application and documents must also physically be submitted to the Ministry of Economy. There's no portal or online portal to submit these, so everything must be submitted physically, and the clock does not start until you physically submit the application and documents. So even though you may email the MOE and provide the documents and application via email, however, the clock will not start until you actually physically submit the documents and applications. With respect to joint ventures, I would recommend waiting for the executive regulations to be issued before obtaining the merger control assessments. There's just way too many unknowns and variables now, so it's, in my opinion, let's wait until the executive regulations come out and flush things out for us. I was hoping that the UAE would have provided a 6-month window before making the turnover threshold effective to allow for a longer transition phase. However, they seem to be in a rush to catch up with the rest of the region. So that is what we have so far in terms of the new developments with respect to the UAE executive regulations. Stay tuned for that. I'm sure as soon as we hear something, we will publish articles for you guys to read and be informed with respect to the same. Moving on and handing it back to our managing partner, Alex Saller.
Well, wonderful. As we conclude today's webinar, I really want to thank all of our speakers for their contributions. I think we've covered all the essential aspects of merger control in the MENA region, from definitions and financial thresholds to exemptions to this new recent UAE development, which is key in the region. At GLA & Co., we're committed to helping you navigate the complexities of merger control. Given the fact that we have people on the ground in all the key jurisdictions who meet regularly with the regulatory bodies, our team stays up to date on all legal developments to provide you with timely and relevant advice. Going forward, please feel free to reach out to us if you have any questions or need assistance. We're going to go through any other questions that are in the chat, and to the extent we haven't answered it, we'll go ahead and do so after today. But again, thank you for joining us today, and we look forward to your participation in future webinars. Have a wonderful day. Thank you.
Thank you, everyone.